No extra.
We're ready on Barham,
Barrow.
and that's Mr. Shepherd.
All right. Good morning. Good morning. PCC and Mr. Barham is right there. All right. All right. So we're on the record. We're on the record. I think we're fifth today.
Yes.
We're on the record in docket 2402-611. That's people of the state of Michigan versus Philip Barham. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Shepherd.
Good morning, Eric Shepherd here on behalf of Philip Barham. We're both present in person in the courtroom, and Mr. Barham is standing to my right.
And sir, you are Philip Barham, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're ready for a preliminary exam date. We're looking at January if the court has any availability. And Mr. Shepherd and I think that maybe we need maybe an afternoon because there is a rather large volume of evidence in this matter, as it is largely a paper case for an embezzlement.
All right, so we're looking for a preliminary examination. I don't know if you were left any dates, but we need probably an afternoon in January.
January 3rd at 1:30.
January 3rd at 1:30.
You have that open there.
January 3rd at 1:30 for the preliminary examination. I would indicate the 21-day was previously ruled on waived on October 4th, and we've set it for January 3rd at 1:30 for a prelim examination that's expected to go concerning the embezzlement. And that's why it's set in the afternoon, which is the key that we're taking some testimony. Anything else for the record in 2402-611, Ms. Wilson?
Not for the people. Thank you.
Mr. Shepherd.
Yes, briefly, Your Honor, I just want to make a record that this is the case where you signed the subpoena and the order to produce some discovery, and that was served upon Mr. Harris and all the different email addresses that are associated with the different businesses that he has. He did send me a responsive document in that it was about 1,000 pages of some entries, Google entries. My clients reviewed that and I've gone through it with him. And in reviewing that, my client indicated to me that there were still about 4 email addresses that were part of the subpoena that there's not been any response given for Google Calendar entries for the associated with those email addresses. So I communicated that to Ms. Wilson because she's been more in contact with him now, and this would be just a follow-up to the subpoena that's already been ordered. And so Ms. Wilson is going to communicate directly to the complaining witness, Mr. Harris, and she's gonna, communicate to him what I've told her about what we believe is missing. So that's going to be outstanding. But between now and January 3rd, I think that gives us enough time. We're not gonna come in here, I don't think, on January 3rd and say, Judge, we've got nothing, we need an adjournment. We'll be in communication between now and then, and we should be able to work out the discovery issues.
All right, and that's a fair statement, Ms. Wilson. Mr. Harris is on your witness list, so he's going to be a witness and subject to cross-examination.
That's correct, Your Honor. And Mr. Shepherd did email me that, and I will be in contact with Mr. Harris. I do believe he's on his honeymoon, so I probably won't get a response until a couple weeks, but I will be in contact with him.
All right, and then Mr. Harris would be available for preliminary examination, cross-examination concerning anything, and he needs to know that so that anything's made available to Mr. Shepherd.
That's correct.
All right, anything else for the record in docket 2402-611, Mr. Shepherd?
No, Your Honor, thank you.
Mr. Barham, we'll see you on January 3rd. Thank you for your appearance today.
Thank you, Your Honor.
How's it going?
Oh, it's pretty good.
Waiting for somebody?
They're on court now. All right.
All right, so we're on the record in docket 24-03492. That is people of the state of Michigan versus Queen Conley. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Conley. Ms. Conley is appearing via Zoom at this time.
And ma'am, you are Queen Conley, is that correct?
Correct.
And you can hear me all right, Ms. Conley?
Yes, I can. Can you hear me?
All right, thank you. I can hear you fine. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe at this time, we're going to leave this set for exam next week. And I believe Mr. Milks and I are going to be in contact with the 54B drug court to see if there can be a referral done.
And that's a fair statement, Mr. Milks.
That is, Your Honor, yes.
All right, so we'll leave this on for prelim for December 12th at 9 a.m. And that'll be next Thursday at 9 a.m. Anything else for the record in docket 24-03492, Ms. Wilson?
Now for the people.
Mr. Milks?
No, thank you, sir.
So Ms. Conley, I'll see you live on the 6th floor of City Hall of Lansing on December 12th at 9 a.m. Thursday at 9 a.m. Okay?
All right. Thank you.
All right, thank you. That's all for the record in 24-03492. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Your Honor.
Mr. Milks, I don't know who's in jail. All right, so we're on the record in docket 22-3409. I gotta make sure I have 24-00387. That was the one we had that started the treatment. 23-03530. And then 23-417-64521. And 24-23-417-64522. It's gonna give some problems. December 12th. and 24-02037. And then 24-02746. This is all set for, all of these files are set for forensic review, or at least I have them set for forensic review. Appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Lavoy.
And Mr. Lavoy is joining us via Zoom from the Ingham County Jail Post. Sir, you are Christopher Lavoy, is that correct?
Yes, sir.
All right, thank you. And you can hear me all right, Mr. Lavoy?
Yes.
All right. This is the time set for forensic review on all the indicated files. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe Mr. Lavoy is still awaiting placement for treatment. So we have not received a follow-up report. So I believe we're going to need another control date.
Okay. And so on the files, they're all in forensic review, and it's my understanding that Mr. Lavoy was deemed incompetent by the report. We had the forensic review hearing, and then we've set it for control date to make sure that we don't lose track of any of the files. Is that a fair statement, Ms. Robinson?
It is, Your Honor.
All right. So we're still waiting the report for review of incompetence or competence stand or incompetence. And so give me a time frame. What are we looking at?
I
here?
think 90 days.
You think 90
I think
days?
that's appropriate.
All right. So we'll take a control date, and this you probably don't have a date for.
We do not.
So I would pick a probable cause conference date in,
And set it for review.
yeah, and set in March. January, February, March sometime.
Sometime, yeah.
Yeah, the end of March.
Yeah.
And then if anything goes wrong, we'll just blame you. Okay.
Yeah, should be.
March 27th
Okay,
at 9 a.m.
perfect. March 27th at 9 a.m. for placement, and then continued report concerning these matters where incompetence has been determined, and we're waiting for the report to follow up concerning competence report. So it's March 27th at 9 a.m. Anything else for the record on 22-03409, 23-00387, 23-03530, tickets 23-417-64521, 23-417-64522, 24-02037, and 24-02746. Ms. Wilson.
Not for the people.
Ms. Robinson.
I would like to address bond, Judge.
All right, thank you. You may proceed.
Yes, Your Honor. Mr. Lavoy has been in custody for quite some time. I think he's going on, it's well over 3 months at this point. And on some of the files, he has no bond on these cases. We'd be asking for a personal recognizance bond or a reasonable 10% bond in these matters. He is working with the social worker in my office to get hooked up with resources and agencies in the community, such as community mental health. And I don't believe that he would be a danger to the community at this time. I have spoken to him at length about attending court and next steps, and he assures me that he will be in appearance for any future court dates and so forth. So we would be asking for bond.
Thank you. I did notice there were some misdemeanors here, some traffic offenses, some others, and then some of these are felonies that we actually started a prelim on. Ms. Wilson, your response to the motion for bond.
Thank you, Your Honor. I'd request the court to leave bond, as is. If the court recalls, the last time Mr. Lavoy was released, he did pick up new felony files immediately, and then he did not appear for court. So I do have some concerns about, him being released at this point, especially considering that there's no mental health issue at play. There are a couple of 10-year felonies here that he's been charged with, so I think that bond should remain as is for now.
All right, and so what is bond on the B and E motor vehicle? Because I have it set, that was the one that he was failed to appear on 3 times.
Mhm.
And then we reset it. We started the prelim and then we had the forensic competency hearing. I have it.
Is that 00387?
That is, yes.
I believe he was remanded with no bond on that one.
I'm gonna keep that one the same, because
Okay.
that's one, the bond set on the other felony is, so this was a good time to just reflect on the charges. I think he was a failed to appear on that also. And I initially set bond at 300 cash. Is that your understanding on the,
On which one?
on 22-034-09? Those are 2 unlicensed dogs.
Yeah, that would be my understanding.
All right, so
I
we
believe- yeah,
can PR on that.
yes.
So I'm gonna set PR bond at $100. On 22-034-09. Because that is a misdemeanor. And then on, but there's, I want to make sure we decipher the important cases from the non-important. But I shouldn't say non-important, but we do have a 23 more severe cases, correct? 23-03530 is a motor vehicle unlawful driving away.
I believe there's a failure to appear on that one as well. We're gonna start I can't remember if we actually started that exam yet or not.
I have bond at 6,010%.
Yep, that was another one that he failed to appear on after he was released last time.
All right, so I'm going to continue bond on that one at 6,010%. And we've reset that for. So. When did we set that hearing for?
March 27th.
March 27th. And I'll keep these just to clear up the notes on them. All right, and then on the impound tow case. And that was from an impounded. We'll PR bond on that. So that's 500 PR bond. And then we have that looks like an expired plates or improper plate. And that is 23-417-64522.
Yes, and I believe the driving offenses came from, I want to say, the same incident as the RNC, but they were written in tickets, so they weren't included in the same file.
Let's PR bond that one, PR bond 500. Or bond modification. And then docket 24-02037 is a controlled substance and a UDA and a resisting obstructing. And bond was set at 25,000 cash surety.
And that is the file that he initially picked up when he was released on the RNC
So
file.
I'm gonna keep bond set at 25,000 cash surety. And then we have 2402-746. And that is a possession of meth. And the bond was set at 510%. I'll continue bond at 510%. Does that cover the 6,000, 10%? So on 2303-530, bonds continued. I think the rest of them are the same. Let me make sure. This one was a PR bond. This is the dog cases. And then this is receiving and concealing. This is receiving and concealing the motor vehicle. I'll continue bond just in case I haven't said it already. We set it for March
27th.
24 at 9 o'clock.
Correct.
All right, Mr. Lavoy, you are awaiting placement and competence evaluation report from the Forensic Center, and we've set this for a control date of March 27th at 9 a.m. where you'll be back, and we'll see if we have the report done at this time. I've set bonds on the misdemeanor files to PR bond. We've kept bond the same on the felony files. Anything else for the record in any one of these files, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor.
All right. Mr. Lavoy, you're all set. Thank you for your appearance today. Because I got to make some notes.
It's a lot to do on the fly.
Yeah, well, yeah. Because we'll be here forever. All right. Where did you want to go next, Miss Wilson?
Aaron, still doing blue?
Yeah.
Yeah, okay. We're ready on blue.
James Blue.
Yes.
Is Mr. Blue here or?
He's in
in
custody,
custody?
yeah.
All right.
Your Honor, can I just actually just have a quick breakout room meeting with Mr. Blue, please?
No problem.
All right, so Mr. Blue, I'm going to put you in with Mr. Sartz as your public defender, and then we'll come back and put it on the record. All right, sir?
Yes, sir.
Thank
All
you, Your
right,
Honor.
so let's see. Visit 4. Let's put you in room 2, and Mr. Sartz will put you in room 2 also.
Yeah, thank you.
You're welcome.
And then we had Ms. Alanis, but I think she got confused and thought she could leave. I'm fine with waiving her appearance if Mr. Etheridge is.
I am, Your Honor. I
All
did
right.
actually talk to her through the
Yes.
video system, let her know what was going on.
All right.
That's Ms. Terrell and
That's Ms. Terrell.
yes.
I did see Mr. I don't know if I saw Miss Alanis. I did see Mr. Etheridge talking to somebody, but we can address that.
Yeah.
So we're on the record in docket 2402-863. That is People of the State of Michigan versus Alexia Alanis. This is the time set for a probable cause conference. Appearances for the record, Miss Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Esperson, Office of Public Defender on behalf of Ms. Alanis. She was here earlier via polyconference in County Jail. She's since been removed from the video. I would waive her presence here as I did discuss what we're going to put on the record with her earlier.
And any objection to the waiver? I believe she was here.
She was here, Your Honor, and I saw Mr. Etheridge speak with her about this, so I have no objection.
All right, Miss Wilson, how are we proceeding?
Thank you, Your Honor. We're still awaiting the finishing of the referral for the mental health court, so I would request another PCC date.
And is that a fair statement, Mr. Etheridge?
Yes, Your Honor.
That will be December 27th at 8:30. So we'll reset this for December 27th at 8:30, and you'll provide that information to Ms. Alanis, Mr. Etheridge.
Yes, Your Honor.
All right. Anything else for the record? In 2402-863, we've adjourned this. And will indicate the 21-day rule was waived on November 7th, 2024. Anything else on this file, Ms. Wilson?
Not for the people.
Mr. Etheridge.
Your Honor, that date is just another PCC date, correct?
Correct.
All right, nothing further.
We've set it for a continued PCC, understanding that we're working through the referral system.
Thank you, Your Honor.
Thank you, Mr. Etheridge. We're all set on 2402-863.
Yeah, right, yeah.
Ms. Johnson.
Johnson, yep.
She's in the courtroom and.
Want to go, Ms. Johnson?
Yes. That should be a second thing.
Mr. Lavoy. Mr. Lavoy
You got them all mixed up.
messed up my system. So. All right, and then I think we'll bring back Bingham County Jail for Mr. Sart's PCC, but let's go ahead and Ms. Johnson.
Ms. Johnson, you can come off.
We're on the record in docket 2402-687. That is People of the State of Michigan versus Collantine Johnson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Esford, Office of Public Defender, on behalf of Ms. Johnson, who is in the courtroom standing to my right.
And ma'am, you are Collantine Johnson, is that correct?
Yes.
All right, thank you. This is the time set for a sentencing in the matter. First off, Ms. Wilson, is there any restitution in this matter?
There is not, Your Honor.
All right. All right, Mr. Etheridge, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
No, Your Honor.
Allocution.
Thank you, Your Honor. For the most part, we're asking the court to follow the recommendation. There are two specific areas that we'd ask the court to consider changing or modifying the recommendation. The first one is the no contact provision of the victim, Leslie Anderson. The prosecutor and I spoke off the record earlier. I just spoke with Ms. Johnson yesterday. She is the legal guardian of the grandson of Mr. Anderson. That's Jalen. She takes care of him, provides medications. She gets very little financial assistance helping him. And she wants to make sure Mr. Anderson has I don't think there's court ordered visitation or parenting time, but she wants him to have the visitation. Jalen is 7 years old and he's asking to see his dad. He wants to visit with his dad. And Ms. Johnson is fine with that and wants that. So the prosecutor and I discussed maybe the court changing the no contact to a peaceful contact by phone to make arrangements for exchanges or arrange visitation or parenting time, and then peaceful contact for her to bring the grandkid to a neutral site in order to make an exchange to give the father the child for the visitation, and then for her to come back and get him at agreed upon sites. And I laid out some of her financial burden or issues about having to take care of the grandson. And I would point out she does have economic hardship. She's on SSI. Most of the money she gets goes to living expenses and taking care of the grandson. So she would ask the court to find her indigent and waive any fines, fees, or costs the court can She is concerned that this will be a financial burden to try to meet all of the recommendations and conditions of probation, on top of having to pay additional costs to the court and oversight fees, et cetera. She has taken responsibility for this from the very beginning. She's taken responsibility, and she would ask the court to take that into consideration. She is remorseful for this happening. Thank you, Your Honor.
Thank you. Ms. Wilson, response.
Yes, Your Honor, thank you. I did speak with Mr. Etheridge, and the last time I spoke with Mr. Anderson, he did express that he wanted to be able to see his son, obviously. It's my understanding that the current guardianship order reads that parenting time is just to be agreed upon between the parties, being Ms. Johnson and Mr. Anderson. So I currently have no objection to a modification of the no contact to a peaceful contact to allow for parenting time for him. Additionally, understanding that Ms. Johnson has the financial hardship and she also has to care for her grandson. I know Mr. Etheridge didn't ask for it, but I have no objection to removing the random PBTs or urinalysis, as there wasn't an alcohol or drug factor in this offense. And I know that that is a substantial burden. And I think the people would much prefer that those resources going towards care of the grandchild than testing that doesn't necessarily seem to be required here.
Right. Any count that I don't think they requested submit to random PBTs, so I don't think that expense. Any response to the fines and costs?
No response to the fines and costs.
Okay. All right. All right, Ms. Johnson, is there anything you'd like to say to the court before the court passes the sentence?
No.
All right. This is for unfortunate conduct that occurred on October 3rd, 2024. I think this involved your grandson. Is that correct?
Mm-hmm.
Is that a yes?
Yes,
Okay.
I'm sorry.
We just have trouble spelling. Okay. I do think your counsel makes fair and reasonable requests in this manner. And I think that's confirmed by the prosecutor's office. So I'm going to indicate that I am going to fine you $100 fine, $100 costs. I'm going to waive the crime victims' rights fee. I'm going to waive the state minimum court cost fee. So that'll be 0 and 0. I'm going to place you on probation for via Zoom for 6 months. It's $30 a month. So that'll be $380 total. So you're placed on probation for 6 months via Zoom. You're to have no contact with the victim, Leslie Anderson, or be within 2,000 feet of where the victim lives, works, goes to school without consent of this court. And then I'm going to place in other, I'm going to write it in, and they hate that because my writing's illegible, but I'm going to write in that peaceful contact can be made with Mr. Anderson in regards to parenting time with his son. Okay.
Okay.
Peaceful contact can be with Leslie Anderson in regards to parenting time with grandson or son. And let me make sure for the order, what is the name of the child?
Jalen Anderson.
Jalen Anderson. I think that's a fair request. All right, so I've written that under other. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription, and no bars and nightclubs. That's already part of this. I am ordering to complete the anger management program that can be set up through the probation department, and not purchase or possess firearms, ammunition, or weapons of any kind. Yeah, you have the 6 months to pay the $380 cost to the city of Lansing. That'll be a part of your probation.
Okay.
Anything else for the record in docket 2402-687, Ms. Wilson?
Not for the people.
Mr. Etheridge?
No, yeah, thank you.
All right. So you're all set, Ms. Johnson. I would contact the fifth floor probation department just to see who you're supposed to report to, but you should all be set. Thank you for your appearance today.
Thank you.
Good luck. Yeah. You can go down now and I'll bring your file.
I'm all right. How are you? No, you're good. What was the other one?
Next, Ms. Wilson.
Wilson, is he downstairs?
No, you wouldn't go.
Yeah, so he would be downstairs.
Christopher Wilson.
Yeah,
I've already talked to him, so you can bring him up.
okay, yeah, if we can bring him up.
So Megan, you can go get Christopher Wilson.
Yep.
Set for sentencing today.
Yeah, he's around. He would. He can have a-
Oh, did you want to do Mr. Sartz's?
Yes, Mr. Blue. Yes.
Sorry, folks, I'm on the record.
Oh.
I'll be out of here in just a second. There's like no conference rooms today. It's just,
No worries. Let me just shut this.
Mr. Sartz, let's put you on the record before you're taking, your conference room is taken away.
thank you, Your Honor.
All right, so we're on the record in docket 2403-505. That is people of the state of Michigan versus James Blue. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth assistant public defender, appearing kind of in person, but I'm actually appearing by Zoom.
All right, thank you. And sir, you are James Blue, is that correct?
Yes, sir.
You can hear me all right, Mr. Blue?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. We'll leave the step for exam next week.
Okay. Is that a fair statement, Mr. Sartz?
That's correct, Your Honor. Thank you.
So we'll leave on for preliminary examination for December 12th at 8:30. So we'll leave on for prelim on December 12th with this next Thursday at 8:30 concerning this matter. Anything else for the record at 2403-505, Ms. Wilson?
Not for the people.
Mr. Sartz?
No, Your Honor. Thank you.
All right, Mr. Blue, we'll see you next week at 8:30. Thank you for your appearance today.
Sir, thank you, sir.
Ms. Moore, are you there? Tracy Moore? We only see the white wall. You'll have to unmute.
What? Yeah.
All right, Mr. Brignoli, you may proceed with allocution.
Thank you. Your Honor, as you're aware, this is a first offense for my client. As indicated when we entered a plea, this was reduced down to an A and B with the request of a delayed sentence under 771.1. My client was employed by the State Department. Due to these charges and the allegations, he lost that job. However, he has the ability to go back to that job or in a contracting work overseas as soon as this is basically done with, and that means off of probation and potentially under the delayed sentence being dismissed. There's a recommendation for the PATS class. Not sure in this situation that would be relatively necessary because this was not a domestic. This was alcohol-induced, inappropriate, touching of the leg and making some comments. There was no relationship involved. My client has unbelievably learned his lesson in this because of the fallout. I mean, losing an incredible job, making a lot of money, going overseas. He's got a child that he takes care of. He's got a significant other. He's got a lot of things going on, and there's been a lot of residual issues because of this. So I would just ask that the PATS not really be something that's added. I think a very minimal term of probation so that he can get this dismissed under the 771 so that he can get back to work. I think any fines and costs that would be owed, he could probably pay them pretty quickly. Other than that, Your Honor, I would ask that the recommendation is fair with no upfront jail or anything like that.
All right, and the request is for 6 months probation. You're asking for something less than 6 months?
That's correct, Your Honor, because until the case is done, this is flagging on his background, and the State Department or any of the contracting agencies will not allow him to travel, possess a firearm, all the stuff that he has to do for work.
Thank you. Ms. Wilson, anything in response?
I think it's the court's discretion.
All right. Well, I've had the opportunity to read the pre-sentence report and take the plea in the matter concerning this matter. Concerning this, and I think this started out as CSC fourth, and then it was reduced to the A and B. I'm going to indicate that this is for conduct which occurred on September 12th, 2024. The defendant is to spend 93 days in jail, credits given for 1 day previously served, suspend 92 days upon successful completion of probation. I'm in agreement that this is a different kind of case. That's not a typical case. I'm going to set fines and costs. $200 fine, $200 costs. Crime victims' rights fee of $75. State minimum court cost fee of $50. We're going to do probation for 4 months. So that's $120 for 4 months. I'll give you a grand total of that. So that'll be $525. Now I can't do math, plus 120, which is $645 to the city of Lansing. Probation is for 4 months via Zoom. That's $30 per month. There's a continued no contact order with Leela Saunders to be within 2,000 feet of where the victim lives, works, goes to school, or without consent of this court. No assaultive or threatening behavior, no use or possession of alcohol, marijuana, or controlled substance. Submit to random PBTs and or urinalysis as directed. No bars or nightclubs. I'm going to strike the domestic violence weekend with verification fees, so that's stricken. Not purchase or possess firearms, ammunitions, or weapons of any kind. So essentially, what people come in front of me, as you know, is for the dropping dirty. I've stricken the domestic violence portion of this because this is a different kind of case. This is not a domestic, and I don't think the programming would be amenable to that. But just be aware that that's generally what people come in, is they drop dirty. So these next 4 months, you need to not drop dirty. All right, you understand that. Anything else towards the judgment of sentence, Mr. Brignoli?
Are you granting the delayed sentence, Your Honor, after the 4 months probation?
I am. So
Thank you.
order. After the completion of probation, we will take a look at the delayed sentence.
Do we want to set a control date?
Yes. Let's set a control date past 4 months.
April.
Trying early April.
Yeah.
369, 120. Yeah, or yeah, I'd say early April or mid-April is fine. April 3rd at 9 a.m. for a hearing on the delayed sentence.
Is that just a paper date where if he does everything, a background, that would just run?
That's what I'm thinking right now. As long as I hear from probation,
Sure.
that's part of the system, then the delayed sentence goes without everybody showing up.
All right, great. Thank you.
April 3rd at 9 a.m. for. So I will indicate for the record, and that is the case, and I will make that note in the file.
All right,
That
thank
I'm
you.
just waiting to hear from probation. All
Thank
right.
you very much.
So Mr. Johnson, you should probably check with probation to see who you're to report to for the next 4 months, to get on with that. And just to make sure that because they're the person, that's the individual who would contact me to say like yes or no. Okay. Anything else for the record in docket 24-02688, Ms. Wilson?
Half of the people.
Mr. Brignoli.
All set. Thank you, Judge.
You're all set, Mr. Johnson. Thank you for your appearance.
Thanks.
Those two. I don't know where Mrs. Moore is.
She popped back in and then she left again, but Mr. Wilson is up
Mr. Wilson.
and Mr. Etheridge is over here as
All
well.
right,
There's Lauren.
Oh, there's that.
Going Mr. Wilson. So we're on the record in the docket 23-00242. That is the city of Lansing versus Christopher, or people of the state of Michigan versus Christopher Wilson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Derek Etheridge from the Office of the Public Defender, Your Honor, on behalf of Mr. Wilson. Mr. Wilson is in the courtroom seated to my right.
And sir, you are Christopher Wilson, is that correct?
Yes, sir, it is.
Thank you. This is the time set for a sentencing in the matter. Ms. Wilson, is there any restitution in this matter?
There is not, but if I could be heard real quick before we proceed to sentencing.
Yes.
So I have in my notes, and I've been having a nagging feeling. I can't remember actually if we took a factual basis at the plea. Because I remember there was a hiccup in the plea, and we broke for a second, and then we came back. And I don't know, I just have this nagging feeling like we didn't actually take a factual basis.
Yeah, I have D2 plea amended count to 200, less than 200. And then I have the Killebrew no upfront jail, probation 4 months, deferred sentence, refer to probation, and the sentence's date. And then I have a defendant failed to appear for sentencing. I'd have to go back and look at the transcript.
I would as well, or at least the video, and I did email Ms. Holden, but I forgot that she was off, so I wasn't able to review it this morning. But if we don't have a factual basis, then we definitely have an issue. And I don't know if Mr. Etheridge remembers if we took one or not.
I just
looked at
don't,
my notes and it indicated that the factual basis was given and you accepted it. I know, I think the facts, if I recall, the factual basis was taken and then finished afterwards. We did take a break so that I could consult with him, and then during the break, and when we came back, it was put on the record that the count one would be dismissed and dismissed immediately. My notes and records indicate we did, but
Okay.
I would defer to the court if the court thinks so.
I have no idea. I just can't remember. And I didn't write, and I did put the nature of the plea agreement. I put there was no restitution at this time. And I put that D was pleading to the less than $200, but I did not put that a knowing, voluntarily, and accurate factual basis was made, which I usually do, but not every time. And but I have no memory of the case, no independent memory. So I would leave it to counsel. I have no, if Mr. Etheridge's notes is correct, he believes the factual basis. I probably feel better if we reviewed
I'm wondering if we could maybe adjourn to next week, and then I can get with Ms. Holden early next week and review.
It'd take her about
the
10 minutes
recording.
to look at the
to look at
transcript.
it.
Yeah.
Just to be safe, because I really don't want this to cause an issue.
Yeah.
And I've had a nagging feeling about this for a while. And
Yeah, I don't have any independent memory of this. And I don't have notes that would suggest, I have notes suggest everything but the knowing, voluntary, and accurate information. With that in mind, that would be, the pre-sentence is done, everything's done. So it's just a matter of
Yeah, could we approach for a minute?
we may.
And could you make me a sandwich, please?
Did what?
I said yes, most of it.
Did none last year.
And I said there is.
For the radio. Is that a radio or people actually? That's beautiful.
See if he was coming for Terrell.
All right, Mr. Delamarter, we'll call your case.
Good afternoon.
Good
Good morning,
afternoon,
I
sir.
should say. Good morning, I should say.
We're on the record in docket 24-03514. That is people of the state of Michigan versus Mark Delamarter. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Delamarter.
And once again, sir, you are Mark Delamarter, is that correct?
Yes,
And you can hear me all right, Mr. Delamarter?
yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe the plan is to leave this set for exam next week with the understanding that this is going to be a misdemeanor plea.
Is that a fair statement, Ms. Robinson?
It is.
So we'll leave on for prelim for December 12th at 9:30 with the understanding that there seems to be a resolution in this case. All right, so that'll be live in person on the 6th floor of City Hall of Lansing. Mr. Delamarter, we've left it on for December 12th at 8:30, and it appears that there's been a resolution discussed in this case. Anything else for the record in 24-03514, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Delamarter, we'll see you next Thursday at 9:30. Thank you for your appearance today.
Thank you very much, sir.
And then I think we're ready on Anisha Thomas as well.
All right, Ms. Thomas. Is Ms. Thomas here?
Yes, she's in the back with Mr.
Okay.
Levine.
And that's Mr. Levine.
Indeed, thank you, Your Honor. I appreciate your. It's not a slight, you know.
All right, so we're on the record in 24-02795. That is people of the state of Michigan versus Anisha Thomas. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Is it Levine or it's Levine or Levine?
It's Levine, you had it right.
Thank you.
Thank you.
Mr. Levine, your appearance for the record.
Thank you, Your Honor. Attorney Barnett Levine, look, good Lord. Barnett Levine on behalf of Anisha. It was a recent change in pronunciation. Mitigates counsel's error. So.
Okay.
And ma'am, you are Anisha Thomas, is that correct?
Yes, sir.
All right. And you can hear me all right, Ms. Thomas?
Yeah.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that we're going to need an adjournment so that Mr. Levine can now get discovery. I think he just got a substitution ready for filing with the court.
All right. And for the record, that Ms. Thomas previously waived her 21-day rule on October 24th. And Mr. Levine, you weren't here, Levine, you weren't here at this time, is that correct?
That's correct. I wasn't there. And
Okay.
just a little bit of an adjustment. So we're still waiting on the signature on the attorney sub back from exiting counsel from the PDs. It was actually Mr. Etheridge.
Okay, all
As
right,
soon as we get that, then I can formally enter my.
all right. So we're gonna adjourn for finishing up the substitution of counsel. And it's December 20th
December 20th at 1:30.
All right. So we'll set for how does that fit, December 20th at 1:30?
It does, and I appreciate the court asking. Okay.
Is that 1:30?
Yes.
Okay, thanks. All right, so we'll set for a adjournment for new counsel and to finish the paperwork on the substitution of counsel. And we'll set for December 20th at 1:30. Anything else? That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 24-02795? Ms. Wilson.
Not for the people.
Mr. Levine.
Not for Mr. Henry, we appreciate it.
All right, Ms. Thompson, I'll see you on that date. Thank you for your
Thank you.
appearance.
We'll see you soon.
If you want to wait a few minutes, Ms. Thomas, I'll have a notice for you.
Okay.
Ms. Moore, are you there? Tracy Moore? You can unmute.
There we go.
Right, I'm gonna have you stay there into the camera because we keep losing you and so we don't call your case. All right? So if I know you're there, we'll call your case.
Oh, okay. Wow.
All right. All right, so Ms. Moore, we're gonna call your case right now, all right?
Okay.
All right, so we're on the record in the docket 2403182. That is People of the State of Michigan versus Tracy Moore. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of Ms. Moore. Ms. Moore is present via Zoom at this time.
And ma'am, you are Tracy Moore, is that correct?
Yes.
And you can hear me all right, Ms. Moore?
Yes.
All right. This is the time set for a probable cause conference. Ms. Wilson, how we proceed?
I would defer.
Mr. Milks.
Thank you, Your Honor. Your Honor, at this time, we'd like to leave it on for the preliminary examination. We've got some updated information from Ms. Moore regarding contact information. So at this time, we'd just like to leave it on. She has been in touch with pretrials or will be in touch with pretrial services following this hearing.
All right, so we're leaving on for prelim on December 12th at 8:30. That prelim will be live in person on the 6th floor of City Hall of Lansing. So Ms. Moore, that'll be a live hearing next Thursday at 8:30. Anything else for the record in docket 2403182? Ms. Wilson.
Not for the people.
Mr. Milks.
No, thanks, sir.
Ms. Moore, I'll see you next week live at 8:30. Okay, ma'am?
All right. See you on last.
All right, you're all set. Thank you for your appearance today.
Okay, thank you. Am I gonna get a chance to talk to Mr. Milks?
Yes, you'll get a chance to talk to Mr. Milks probably later in the week, but
Tomorrow, we said,
tomorrow.
right?
Okay.
All right.
Talk to you then.
You're all set. Thank you, ma'am.
Okay. Bye-bye.
On the cell phone, 4740, just on not Miss Culpepper on the iPhone, on the cell phone, could you please identify yourself?
Jatavian Embry.
Embry.
Yeah, Embry.
Right, you're here for your 9:30.
Yes.
All right, that's yours, Miss Robinson. All right, so we can do Ray and then we can do Embry.
Sure, I'm gonna probably need to talk to Mr.
All
Ember
right.
first, but
All
if
right.
we can do Ray and then I can get a breakout
All
room with
right,
him.
perfect.
Ray's in the waiting room.
No.
Just
Oh.
joined.
Yeah, I spoke to him yesterday, so I would be surprised that he wasn't here.
All right. You've let him in?
Yep,
Is he the one with the hat?
he is the one with the hat.
All right. Caleb Ray, we're gonna call your case. You can unmute.
Looks like he just left. I having issues.
I did have good contact with him, Judge, if we want to just go and I can call him after,
All right.
after court today. We've already worked out a plea agreement and
All right.
everything on the case.
And that was set for PCC today, is that?
Yeah, that's
correct?
correct.
And he just came and then left, so. All right, so we're on the record in docket 24-03-510. That is people of the state of Michigan versus Caleb Ray. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Ray.
All right, this is the time set for PCC. Mr. Ray had joined us briefly via Zoom and then left. Ms. Robinson has indicated that she will be in contact with Mr. Ray. So we're waiving his appearance right now.
That's correct.
All right. Is that a fair statement, Ms. Robinson?
It is, thank you.
All right. Ms. Wilson, how are we proceeding on the PCC?
Thank you, Your Honor. We're going to leave this up for exam with the understanding that this will be a misdemeanor plea.
All right. Is that a fair statement, Ms. Robinson?
It is, Your Honor.
So we'll leave on for December 12th at 9 a.m. And my understanding, there's been a resolution reached by the parties. And we'll address it on that date. So it'll be live in person on the 6th floor City Hall, Lansing, for December 12th at 9 a.m. Anything else for the record in 24-03-510, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
Thank you. We're all set on that file. And he
Hop in Zoom real quick.
he
He's in the
just
waiting room again.
admitted, and I'll just tell him we've left it on. And then you're gonna meet with Mr. Embry, right?
Yes.
Okay.
Oh, he just came back.
Okay. So, Mr. Ray?
Yes, sir.
All right, we've left your prelim on for next week. And you should contact Ms. Robinson. I understand that there's been negotiations between yourself and the prosecutor's office, and Ms. Robinson will tell you all about that. But we've left it on for prelim next week at this time. All right, sir?
So what time come back next week?
Next week, you need to come back Thursday at
9 a.m.
At 9 a.m. Yeah, you should be here live on the 6th floor of City Hall of Lansing, Thursday at 9 a.m.
Should be on his last notice.
Yes, sir.
Yeah, it should be your prelim notice. And then if you want to talk to Ms. Robinson, you can talk to her before that date.
All right, thank you, sir.
You're all set. And then Ms. Robinson, you wanted to talk with Mr. Embry, is that correct?
Yes, sir.
All right, so let's go. I'm going to assign you to room 1, and then I'll assign Mr. Embry to room 1.
Do we have him post 2?
In the Ingham County Jail Post 2, could you please identify yourself? Is that are you Mr. Blakely? I think that was a yes.
I think it was a yes, but we don't have audio.
Oh, I had to mute him because there was a lot of background noise when Wilson's case was going.
So you sir, give me a thumbs up if you're Lonnie Blakely. All right, perfect. All right, we'll go on your case as soon as Mr. Milks.
He's here.
Oh, did you want to go? Did you want to go, Mr. Blakely?
Sure.
The only thing is Mr. Blakely is muted. Let's make sure he's off mute. Oh, I think, perfect. All right, so that is 2 files. All right, so we're on the record in docket 20-02438 and 22-02196. That is people of the state of Michigan versus Lonnie Blakely. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Blakely. Mr. Blakely is appearing via Zoom at this time at the income jail.
And sir, you are Lonnie Blakely, is that correct?
Yes.
And you can hear me all right, Mr. Blakely?
Yes.
All right, thank you. This is the time set for a probable cause conference on both of these files, and we can go one at a time. You can address the files one at a time. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to leave both set for exam.
Is that a fair statement, Mr. Milks?
It is, Your Honor. I'd like to make a quick record too.
All right. You may make that record, Mr. Milks.
Thank you, Your Honor. Your Honor, I have not spoken with Mr. Blakely. I'm sure he's aware of that at this point. I was appointed on 12/3 this week. I've been out sick for most of this week. Not even aware of this. I've got a meeting scheduled with him tomorrow over Polycom, so I will be able to speak with him, but at this time, I've not had the chance to speak with him due to a last-minute appointment, apparently. And again, being appointed while I was not in the office. So I at least want to make that so I have not spoken with him, but obviously through no fault of his. I just want to make that record.
All right, and so you'll be meeting with Mr. Blakely tomorrow.
I will, Your Honor, yes.
All right, so we are leaving on for preliminary examination, which is previously set for December 12th at 8:30. And Mr. Blakely, you will be talking to Attorney Stephen Milks tomorrow on the preliminary examination for both files. All right, sir?
Yes, sir.
All right. Anything else for the record in 20-02438 or 22-02196? Ms. Wilson.
Not for the people.
Mr. Milks.
No, just my most sincere apologies to my client, Your Honor, for this office mishap.
All right, so Mr. Blakely, we will see you next week, December 12th at 8:30. Thank you for your appearance today.
Thank you. That's it. I can go.
Yes, you're free to leave.
Okay, thank you. Have a good day.
You too.
Good stuff.
All right, Mr. Embry, we'll call your case. We're on the record in docket 24-03513. That is People of the State of Michigan versus Jatavian Embry. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Embry.
And sir, you are Jatavian Embry, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Embry?
Yeah, I can hear you perfect.
All right, thank you. This is the time set for a probable cause conference. Ms. Wilson, how are we proceeding?
I believe we're going to leave this set.
Is that a fair statement, Ms. Robinson?
That's correct. Thank you.
So we'll leave on for preliminary examination that has been previously set for December 12th at 9:30. That'll be live on the 6th floor of City Hall of Lansing. Anything else for the record in docket 24-03513, Ms. Wilson?
Not for the people.
Ms. Robinson.
No, Your Honor. Thank you.
All right, Mr. Embry, we'll see you next week. It'll be next Thursday at 9:30, live on the 6th floor. All right, sir?
Okay,
You're all set. Thank you for your appearance today.
thank you.
All right, Ms. Matula, we'll call your case. So we're on the record in 24-02072. That is People of the State of Michigan versus Aaron Matula. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning again, Your Honor. Stephen Milks on behalf of Ms. Matula. Ms. Matula is appearing via Zoom at this time.
And ma'am, you are Aaron Elizabeth Matula, is that correct?
Yes.
All right, thank you. This is the time set for a sentencing in the matter. Is there any, Ms. Wilson, is there any restitution on this case?
It appears LPD is requesting $15 for a DNA collection.
I have, that has to be a misprint. So LPD is requesting for DNA collection, that's $15?
It appears so.
All right. And then I have probation is for 12 months. That should be $360, right? I have $3,650. I would assume that would be the objection.
Yes, Your Honor, that would be.
No.
So $360 for probation is the request. All right, Mr. Milks, have you had the opportunity to go through the pre-sentence report with your client?
Your Honor, we did have that opportunity to review the report. Upon review of that report with my client, there are no corrections, deletions, or additions to be made to it.
Allocution, Mr. Milks.
Thank you very much, Your Honor. Your Honor, first and foremost, my client is currently on probation, is my understanding. And as she's on probation, we were asking that she have the opportunity to have that probation possibly transferred. If not, I see that it's Zoom reporting. We would request that it be kept there. Additionally, Your Honor, my client is engaged in treatment, mental health treatment. We understand the need for assigned release. I don't know if moral recognition therapy is what she needs at this point. I would ask that there be some sort of assessment maybe, or at least just that she follow up with her probation officer to see where they're at regarding her ongoing therapy at this point. This entire situation, Your Honor, was due to mismanaged medications here. Okay. She has rectified that. Since I've known her, she has been very easy to work with, very understanding, and incredibly remorseful of what she did, understanding that this is not who she is. Due to an imbalance of medication, it obviously led to this situation. She's monitoring that, and she's been doing very well in that, Your Honor. So for those reasons, Your Honor, I would ask that she be given that opportunity for the Zoom recording specifically, and at least to just continue with her ongoing mental health treatment, Your Honor.
Thank you. Ms. Wilson, anything in regards to allocution?
No objection to the request to strike the
Moral recognition
yeah.
therapy.
The mental health treatment is really the biggest thing that the people wanted to see here. So as long as that remains, we have no objection.
Ms. Matula, anything you'd like to say to the court before the court passes sentence?
I just wanted to say that since I did meet with my probation officer, it was not an option to transfer, but the probation officer did tell me that we were able to do it via Zoom.
All right. And is your probation officer Mr. Sumter?
Yes.
Okay. All right. All right. Anything else you'd like to say to the court before the court passes sentence, ma'am?
No, thank you.
All right. This is for conduct that was found on guilty plea made on October 11th, 2024. The court will order 30 days in jail, credit given for 1 day previously served. I'll suspend the 29 days upon successful completion of probation. So there's no upfront jail in this matter. Probation can be via Zoom. I will set fines and costs on the 1 year misdemeanor, $200 fine, $200 costs, crime victims' rights fee of $75, state minimum court cost fee of $50, LPD restitution of $15, and that was already on here, so I'll strike the. And then probation for 12 months to the Union County Probation Department. So that'll be a grand total of 400 plus 75 plus 50 plus 15 plus the 360 for $900. That can be paid over the course of probation. Probation for 12 months via Zoom is appropriate, and that's $30 a month. No contact with the victim in this case, Brandon Montemayor, or to be within 2,000 feet of where he lives, works, goes to school without the consent of this court. No assaultive or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. Submit to random PBTs and or urinalysis as directed. No bars or nightclubs. I am striking the moral recognition therapy at this time. Based on council's comments, you will have to sign a release so you continue with the mental health and release treatment. So the probation department gets an idea of what the treatment is and then can make any motion in that regard. But they can't get that information unless you sign the release. All right, ma'am?
Yes.
All right. There's obtain or seek or maintain employment, not purchase or possess firearms, ammunitions, or weapons of any kind. Anything towards a factual basis on 20-02072, Ms. Wilson.
Towards the judgment of sentence, no, Your Honor.
All right. Mr. Milks.
No, nothing further. Thank you.
Ms. Wilson, anything else on this file?
No, Your Honor, thank you.
All right. Ms. Matula, do you have any questions of me concerning the judgment of sentence?
No.
All right. You should probably, you've been in contact with Mr. Sumter. He's the person that you've got to keep happy. All right. So make sure you contact him in regards to anything that's that the court has ordered. Really, the mental health treatment and the signed release are the most important aspect at this time. I've stricken the moral recognition therapy. All right, ma'am.
Okay, thank you.
All right. I will sign the judgment of sentence accordingly. Anything else for the record on this file, Ms. Wilson?
Not for the people.
Mr. Milks?
No, thank you, sir.
You're all set. Thank you for your appearance today, Ms. Matula. You're all set.
Thank you.
And I do have an update. Mr. Feigelson indicated that he was not aware that Ms. Terrell had court today and requested that I have somebody from his office fill in. So I told him I was going to make Mr. Milks do it.
Okay.
We'll do Miss Culpepper first for sentencing.
Yep.
And then we will
Just a forensic review.
and then we'll go on Miss Terrell's case, which is just a review.
Yep.
Let's go on Miss Culpepper. And then Miss Terrell. Is that a control date?
For
Miss
Terrell, I believe it was a control date. I don't recall receiving.
All right, Miss Culpepper, we'll call your case next, your sentencing, and then we'll call Miss Terrell. All right, so we're on the record in docket 23-01100. That is people of the state of Michigan versus LaShawn Culpepper. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
Yes, and good morning again, Your Honor. Stephen Milks on behalf of Ms. Culpepper. Ms. Culpepper appearing via Zoom at this time.
And ma'am, you are LaShawn Culpepper, is that correct?
Yes.
All right, thank you. And you can hear me all right, Ms. Culpepper?
Yes.
All right. this is the time set for your sentencing in the matter. Miss Wilson, I have restitution at $4,666.08, and that's been followed with a restitution form. Is that correct?
That's correct, Your Honor. And I just want to clarify on the PSI that I have it as going to GPM Investment. I know that this was from an Admiral gas station. I don't know if GPM Investments is like a parent company.
I would think. I don't know. Let's see.
I just want to make sure it goes to the right.
But
Yes, it is.
yeah, the total amount owed stated in the report from GPM Investments in the Lansing report is $4,666.08. That is, so that would be from the police report, an indication that that is the holding company.
Yes, okay.
All right. With that understanding, that is restitution. Mr. Milks, have you had the opportunity to go through the pre-sentence report with your client?
We did have that opportunity, Your Honor. It's my understanding that there are no corrections, deletions, or additions to be made.
Allocution of Mr. Milks.
Thank you, Your Honor. Your Honor, this is a complete financial situation where, you know, she admitted right away that she did take money from her employer. The recommendations here that she attend an anger management program and or mental health counseling, Your Honor, I don't see why that is entirely appropriate here. She has been working, she's been moving from better employment to better employment. Right now, she is working at McLaren Hospital in their food services, Your Honor. So she is trying to make good money as well as trying to provide for her family. She understands and fully accepts responsibility for her actions here, wanting to pay back the money that she's owed. She hasn't even had an objection regarding the restitution here. I feel like in part of her interview here, it's being held against her that she was being upfront and honest, saying that when she was younger, at least, she did have to steal in order to survive. There's no indication that she's been doing that. Again, outside of this situation here, obviously, Your Honor, where she is admitting responsibility and taking care of that. Don't understand the anger management or the mental health requirements here, as I don't think they're appropriate in the situation or they applicable to her actions here. For those reasons, Your Honor, I would ask the court adopt the recommendations, but limited to essentially like a non-reporting probation to ensure that she's making payments, which I know she will begin doing and do make every effort to do so. So again, I'd be asking for a non-reporting probation here, sir.
All right, thank you. Any response, Ms. Wilson?
Thank you, Your Honor. The people are in agreement that the anger management services don't really seem to be in line with the offense that happened here. As far as the mental health counseling, I think the reason probation got into that was because there was, in the interview, there was something about stealing being a compulsion or an addiction or something. And so I think that's where it came into play. As to the mental health counseling, I'll leave it to the discretion of the court. But the remainder of the recommendation I find appropriate.
I think some of it came from the report based on the conversation that the probation have had with the defendant, indicating some issues concerning mental health and anger management that had previously been discussed. I understand that, so I understand the request. There's also a GED program, and that's obviously a part of the discussion because that was part of the discussion. And so I think I understand I understand the judgment of sentence, but I also understand that this doesn't fall in line with the type of case, but it's based on the conversation. All right. Ms. Culpepper, is there anything you'd like to say to the court before the court passes the sentence?
No.
All right. You understand that the court is looking at, it's been requested, anger management has been requested, and mental health counseling and GED. Do you have anything to say about those matters?
No, I talked to my probation officer about that.
All right.
I'm sorry. My biggest concern there is the financial cost, because sometimes probation doesn't explain that, look, these are added costs.
Right.
If they were free, I would be fully on board with it. But due to her financial situation, restitution and having to take care of a family. That's my biggest concern.
I agree. I have some, this is also a huge restitution order in this case. All right, so the, so for let's find this. For the guilty plea, which was on October 3rd, 2024. It is the order of the court that you be placed. I don't know how many times. Is there any time in on this?
I don't think there is.
All right.
So I'm gonna indicate that you're to spend 0 days in jail at this time, and credit is given for 0 days previously served. That's today's date, starting today's date, 12/25/2024. You're placed on probation for 12 months. We have fines and costs. I'm going to set fines at $200, cost of $200, crime victims' rights fee of $75, state minimum court cost fee of $50, a restitution of $4,666.08, and then probation at $360. And I'll give you a total for that. Plus 360. So that's $5,551.08. Restitution is go to GPM Investments. That's the $4,666.08. Placed on 12 months probation at $30 a month. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. No bars or nightclubs. I am striking any anger management program. I am indicating that you should continue whatever mental health counseling you're on and sign a release in regards to that. That may be an issue here, and I think that should consider, I'll leave that in the hands of Mr. Hanna, your probation officer, that he gets an update on any mental health counseling that's going on, and you'll have to sign a release for that update. All right, ma'am?
Yeah.
All right. Obtain GED or high school diploma, or obtain and maintain employment, and we'll leave that in the hands of Mr. Hanna, and not to purchase or possess firearms, ammunition, or weapons of any kind. The total amount of $5,551.08 can be paid over the course of the year of probation. I'll leave Mr. Hanna to oversee that. Anything else for the record in 23-011-00, Ms. Wilson?
Not for the people.
Mr. Milks, do you have any questions of the judgment of sentence?
No, thank you, sir.
All right. Ms. Culpepper, you should contact Mr. Hanna. He's your probation officer, and continue. He's actually the one who would violate you. Really, this is really about the restitution and the mental health counseling or continued mental health counseling. Sign any release and then stay employed. All right, ma'am?
Yes. He excuse
All
me.
right.
He got me set up to do anger management at Crystal Ray.
Yeah, he has set it up. I've stricken it. Unless, but you can always do that on your own. Okay, you can. I've just struck it from the order because because you owe so much in restitution that they're going to make you pay for that, and I think that should go to the Admiral gas station. All right, ma'am.
Okay, thank you.
All right. That's all for the record in 23-011-00. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Thank you.
You're all set, Ms. Culpepper.
No, we're doing that right now. Yeah.
This is Terrell.
Yes.
This is Terrell. All right, so we're on the record in docket 24-02344. That is People of the State of Michigan versus Cecilia Terrell. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Milks.
Yes, and good morning, Your Honor. Stephen Milks, on behalf of Ms. Terrell. I'm standing in for Attorney of Record Stephen Feigelson.
And ma'am, you are Cecilia Terrell, is that correct? Oh, let's make sure we can hear you. So we'll have the Ingham County Jail Post unmute you because you're on mute. And you might want to let them know that you're being muted and it's time to unmute you. All right, so while we're getting Ms. Terrell's unmuted, let's go on with this case because we're trying to sneak it in before a prelim started.
Fred, can you go grab your guy real quick?
Pardon me?
Can you go grab him? Real quick?
Why, we don't have an interpreter.
Yeah, we don't have any interpreter.
Is this for Eric?
Yes.
Yes.
Perfect.
All right. So you're here on El Abbas?
Yes.
Or I'm sorry, Saif Ez.
Yes.
All right.
Perfect.
All right. You can come up here. Did you want to, is your client here, Mr. Blackman?
Yeah.
Yeah, he's in the hall.
Let's bring him up and we'll put it all on the record and it's an adjournment.
Judge, you only, I'm gonna have to, I know you're busy right after.
Yeah.
Mr. Blackman, do you have to be somewhere else?
No, there's some other issues, but I'll talk to them about those.
All right. All right. And I'll make a record as to what happened. Because this changed over the course of
last night. Hours.
Yes. Yeah. I have an email that I brought just for that. So.
Where I was respectfully losing my mind.
You and
a lot of things, not just this. Let's be fair.
Yeah, that was the latest
court officer and ma'am, you can come up here.
The last thing I want is for her to be here, and then she doesn't have an interpreter for me to explain why it's not.
There was just some communications, and we'll.
Yeah.
Where you want it to be?
Okay.
All right. So, ma'am, I'm going to have you please state your first name and last name for the record.
My first name is Rose, R-O-S-E. My last name A-J-A-K. Ajak.
I'm going to have you raise your right hand. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications? So if you got under the penalty of perjury.
Yes.
Okay, thank you. All right, you just let me know if I get going a little fast, all right? Okay, all right. So we're on the record in 24-02344. And that is people of the state of Michigan versus, I have the wrong file here. I still have Ms. Terrell's file here. Safe ANS. Will the parties please introduce themselves for the record? Ms. Wilson, Mr. Pfeiffer.
Yes. Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Black.
Your Honor, Fred Blackman on behalf of Mr. as he is standing to my right at the podium.
And sir, you are safe as, is that correct?
Sir.
This is the time set for a preliminary examination today, and then I'll make a record, and then I'll let either party make a record to supplement. It came to our attention yesterday afternoon that we may not have an interpreter in this case. And so there were issues with communication as to whether we were going to have an interpreter or not. So we didn't know that. So Mr. Pfeiffer asked, the prosecutor asked if he could call off his witnesses.
Well, so hi, Zalama, I also شاركتك إذا كان يكون الناس الشاهدين الشهود لازم متأكدين إذا كان الشهود يكونوا هم ولا لا عشان كانوا متأكدين.
And that we received that communication, and I don't know if that was communicated to Mr. Blackman or not.
So هم متأكدوا إذا كان هو بيعرف كان في مترجم ولا لا عشان الشهود تبع.
I included Mr. Blackman's email in that chain.
All right.
Judge, and during that whole time, I was waiting with safe.
Okay.
So I was getting bits and pieces of it.
Yeah, and this was all coming out yesterday afternoon.
Yes.
So كله هدف امبارح مثلا
And then this morning, we found out that we may have an interpreter. And that's why we have the interpreter here, which is all good because we put it on the record.
The issue, Your Honor, was the interpreter for the victim. And the company told us the only interpreter they could have available after they canceled was one by Zoom. And
that's not going to work.
Correct. I saw nothing but problems with that.
So the problem was with an interpreter for the victim, not for the defendant's interpreter.
Correct.
All right. So I find good cause to adjourn. Obviously, I find good cause to adjourn. So good cause to adjourn the matter. And then Mr. Pfeiffer, you can make a record, and I'll leave Mr. Blackman to make a record also.
Thank you. My office was informed by 7C Lingo less than 24 hours ago that the interpreter that we've had lined up for the better part of a month had to cancel. There was no one else that they could get that was not either, that was both certified and also in person. Every option they gave were not ones that were legally or practically sufficient in order to hold a preliminary examination. So as soon as I found that out and got out of my circuit court matters, I immediately emailed the court as well as Mr. Blackman to try and, try and address this thoroughly.
Right. As best you can.
Yeah.
البارت الثاني المفروض يكون عنده مترجم من 7 سنين وتبع 5 لكن هم ما ينفع اللي بعد 24 ساعة.
So the prosecutor's office is lining up the witness's interpreter. And what is that in? What language?
Arabic. Your Honor.
Arabic. Okay.
I don't remember if there's a specific dialect though, at this moment.
All right. And then Mr. Blackman, anything you'd like to say for the record?
Other than what's been stated is that I got that, and when we were sitting in the office, I had informed Safe when we were sitting there that the exam was off, and I wanted him to, I wanted him to come to court today with me.
All right. And the 21-day rule was previously waived on October 23rd. And you should.
Okay.
Yeah, you
Say
can.
that again.
The 21-day was previously, the 21-day rule was previously waived on October 23rd.
So اليوم الأصل كان واحد شيء.
And we will order an Arabic interpreter for the defendant at the next hearing. And then the prosecutor's office will take care of the Arabic interpreter for the witness. And we will adjourn to
January 9th at 9:30.
and then Mr. Blackman, you should check your schedule.
I was staring at January 9th.
Okay. That rarely happens. January 9th at 9:30 for the continuation or to start the prelim.
Yes.
And you'll get notice of that January 9th date from my court officer. Anything else for the record?
Judge, I want to put one, I haven't talked to Adam about this yet, but when my client was in my office, there's some issue about some phones, his phones that haven't been returned to him by his spouse. Money that's being taken off credit cards that he wants back. And also, pardon me?
She used my credit card.
Yeah, I know, and been using your credit card, so we're concerned about that. We want that stopped.
Right.
There is a divorce pending. And some of these issues might be a divorce and not, but I will discuss this with Ann. If we can't figure it out, file a motion prior to that or something, but my client is, money's being taken.
All right, who are the attorneys on the divorce? Do we know?
I know.
That the money part seems civil in nature.
Yeah, it does seem civil in nature, but I don't want, but it does seem
seems
civil in
very-
nature. But he should probably contact his civil.
Well, no, he's talked to, I mean, we talked about that yesterday, and that if I can't figure that all out shortly, we'll revisit that very quickly.
All right, all right.
And then the only issue that I have, Your Honor. Hold on. I can wait.
I know, yeah. And he just, a friend of my clients just indicated to me the same thing.
Okay.
She's been using a credit card and and we're
Yeah,
concerned.
and also, as you know, he probably should contact his civil lawyer.
And one other thing is that all the furniture that is his family's is up for sale in the house for some, and remember, we've got problems.
Definitely part of the divorce.
Yeah, okay.
Yeah. Everything, the picture, the video.
Yeah, because the two private phones that I think are a serious issue is that a lot of videos of this incident are on those phones.
Well, I think both parties would probably.
Yeah, we would love those. I mean, that's why we need those back.
I'll leave that between you and Mr. Pfeiffer.
Okay.
This is, and the divorce, the also divorce in this case.
Much of that is nothing I am going to touch with a 10-foot pole.
All right.
One issue that the people have. I think it was yesterday, Mr. Blackman dropped off to my office some videos and photos that the defendant had given to him. Of concern to me is there's screen grabs of videos from the property she's at, from the surveillance systems there, that are dated after he was arraigned, which means he's been accessing the surveillance at her house where she's living. And while that's not a violation of bond, it is concerning. I know that there have been prior issues in other cases, this court's dealt with very similar, where the resolution has been in order for him to disconnect from those services. I'd ask that that be issued here.
Mr. Black.
Judge, I'm not really aware of that particular thing, but if there comes an issue, I'll talk to my client about it.
All right, the no contact order is direct or indirect.
Okay.
So, I mean, so he should not put himself in a position where he's in indirect contact with him, just so he doesn't want me to review it. You know, I mean, that would be the safest ploy at this point.
I agree.
Okay.
They called me yesterday. Her friend, they called me yesterday. No, they tried to call me yesterday.
Okay, I'll talk to my client about it. I'll talk to you about that. Okay.
I'd just like there to be an order from disconnect from the surveillance systems at her house where she's currently living.
So Mr. Blackman, the order right now would be no direct or indirect contact.
Right,
And
right.
so any review of any systems at her house would be problematic, I would think.
Understand.
The concern is that that doesn't fall inside direct or indirect contact because he's not contacting her. He's remotely accessing her surveillance cameras and able to effectively spy on where she's at.
Right, well,
that's the people's concern.
just to keep it clean, he should.
I understand, Judge, exactly
When
what
he
you're saying.
disconnects, then we don't have an issue.
Yes.
Yeah, when he disconnects, we don't have an issue.
Okay, Judge. I
All right.
understand. Okay.
All right, so we'll set it for the prelim adjournment for January 9th at 9:30. Anything else for the record on 2403140,
Not from the
Mr. Pfeiffer?
Not from the people.
Mr. Blackman?
Not today, Judge.
All right, thank you. You're all set. Thank you for your assistance today.
Thank you, Mike.
Yeah, that's fine.
I'm gonna start my other two exams with your son.
This is on the census. I just didn't.
Oh, okay.
I believe. Let me see that. Let me see what I just said. I think I just confused Culpepper and Culberson, so I've got Culberson.
And then it sounds like Mr. Welsh.
All right, so we're on the record in docket 2403511. That is people of the state of Michigan versus Paris Mendenhall. Will the parties please introduce themselves for the record? Ms. Lawton.
Abigail Wilson for the
Oh.
people. Sorry.
You can't change
Switch
out.
it up, I know.
It confuses me. Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender. I'm appearing on behalf of Ms. Mendenhall this morning. I'm here in person. Ms. Mendenhall is not present. She's in the jail. She was going to appear by Polycom, but I'll waive her appearance for today's proceedings.
And Ms. Wilson, you're also waiving the defendant's appearance for these proceedings.
We are, Your Honor, thank
All
you.
right. This is the time set for probable cause conference. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. At this time, we're gonna leave this up for exam.
Okay, so is that a fair statement, Mr. Sartz?
Yes, Your Honor, there is a misdemeanor offer. I anticipate Ms. Mendenhall might be interested in taking that. However, it would be a potential probation violation for her. She is going in front of Judge Dragonchuk next week. But Your Honor, I'll follow back up with her. I would think the odds are probably pretty good. She's going to be accepting the misdemeanor plea offer at the date of her scheduled preliminary examination, and I will update Prosecutor Wilson as soon as I'm able to do so.
Thank you, Mr. Sartz. So we'll leave on for prelim on December 12th at 9 o'clock. I indicated the negotiations are continuing in the matter, and this may be a plea depending on what happens with the circuit court case. Anything else for the record in 2403511? Ms. Wilson?
Not for the people.
And Mr. Starks, you'll obviously communicate the same to Ms. Mendenhall, is that correct?
That's correct, Your Honor.
All right. Anything else on 2403-5.1, Mr. Sarks?
No, Your Honor, thank you.
That's all for the record. Thank you for everybody for your appearance.
Last thing I have.
Yeah, good. And then
So, Ms. Terrell, you're still muted. Yeah, we're trying to figure out how to unmute you. All right, you've just been unmuted, ma'am. So let's put you on the record in docket 24-02344. That's people of the state of Michigan versus Cecilia Terrell. Parties, will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
Thank you. Stephen Milks from the County Public Defender's Office. I'm standing in for Attorney of Record Stephen Feigelson.
And ma'am, you are Cecilia Terrell, is that correct?
That's correct.
Okay, and you can hear me all right, Ms. Terrell?
I can hear you perfect.
All right, thank you. This is the time set for forensic review. It is my understanding that the defendant was to meet with forensics while she was out on November 15th, and that's when the bench warrant was issued because we had a fail to appear for forensics appointment. The defendant was arraigned on November 24th, and now we're waiting forensic review, the actual report to be done after the evaluation. Is that a fair statement, Ms. Wilson?
It is, Your Honor. Thank you.
All right. Mr. Milks.
Yes, Your Honor. Our notes do seem to reflect that at this time, that we're still just waiting on her to get interviewed.
All right. So, Ms. Terrell, you're in on the bench warrant because you have to be evaluated because you failed to appear for your appointment. You understand that, ma'am?
Yeah, I think it was just a miscommunication. I thought everything was December 5th. So I thought, from what I read from my paperwork, I thought December 5th was going to be the forensic review and the court date. So I do apologize for not appearing for that.
I would assume that forensics is going to be out to see her.
I believe once they're in custody, they're notified of it.
Okay, and so, and then I think any bond modification can be made or once she's evaluated.
Correct.
So I'm looking, once they come and see you, I'll entertain any motion reduction, and you can indicate that for Mr. Feigelson of the office, that we'll look at modifying bond. If this was just a missed appointment, but we've got to get you evaluated in order to proceed. All right, ma'am?
Okay.
All right.
Do we know when?
So probably, I would think if you've been set for review by the 15th, they've been notified, and we will notify, the court will notify them. So hopefully within the next week.
Forensics has within 60 days to get the report completed. So hopefully well before then.
And make that note. And so each make that note because I'll bring them in if I have to, you know. We've done that before. We've ordered a report to be done now. And so we're just waiting for that report. It should be done in the next week, but I'm uncertain.
Okay.
All right. So we will set this for control date. All right, so those are all felonies.
Yes.
All right, we'll set control date 30 days out, you think?
I think so.
Yeah. So let's set the control date just to meet again, to make sure that we don't lose track of the case. We'll set a control date for 30 days out at?
Oh, excuse me. We can do January 9th at 10 a.m.
So we may not need this date because you'll be seen by forensic before, but we've set it for a date just in case, all right? We've set it out just in case, so we don't want to lose track of the file. Anything else for the record in 2402344, Ms. Wilson?
Not for the people.
Mr. Mills?
No, thank you, sir.
All right, Ms. Terrell, you're all set. Thank you for your appearance today, and thank you for your patience.
Thanks. Thank you.
Let me know when you're done, okay?
Yes, sir. Yeah.
Record in docket 24-03068. That's people of the state of Michigan versus Takesha Culberson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Culberson. Ms. Culberson is present via Zoom at this time.
And ma'am, you are Takesha Culberson, is that correct?
No, sir. I'm Mendenhall.
You're Miss Mendenhall?
Yes, sir.
Oh, okay.
Okay, so you need to talk to your attorney, Mr. Sartz, we've left it on for prelim, and my understanding is negotiations are continuing. All right, ma'am?
Yes, sir. That means court is over?
Yeah, you're all set here. I'll see you next week. And if you have any questions, Mr. Sarts will be out to see you.
Next week on the 12th, correct?
Correct. Yep.
Oh, yes, sir. Thank you guys and
Yeah,
be
so-
safe out there.
So thank you. And you can tell them to Miss Culberson should be in your place.
Ms. Colson.
Miss Culberson, correct.
Yes, sir.
Thank
Yes,
you.
sir. Mason.
so we're on the record in docket 24-03068. That's people of the state of Michigan versus Takesha Culberson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And Stephen Milks on behalf of Ms. Culberson. Ms. Culberson, we are waiving her appearance today in court. I will let the court know that I already had a chance to speak with her on November 27th, and she confirmed with me that she would like to waive today's proceedings.
Oh, so
I'm sorry, that she would like to leave it on for next week. Yes, sir.
All right.
Yes, sir. Thank you.
All right. So Ms. Wilson, is that a fair statement? We're leaving this on for preliminary examination.
That's correct.
You scared me there first.
I did too.
I scared myself. Yeah,
that.
yeah.
Like, I don't know how to do that without the defendant present, but we'll leave on for preliminary examination for December 12th at 8:30. And per the record, Mr. Milks, you've discussed this with your client, and you'll continue to keep communication with Ms. Culberson. She's incarcerated. She was not placed on Zoom. There was somebody else placed on Zoom in her stead. And so at this time, we're just leaving it on. Is that a fair statement, Ms. Wilson?
That's correct, Your Honor.
Mr. Mills.
That is, Your Honor, and I will reiterate, she wanted to leave it on for next week, not waive. So yes,
okay.
Fine with that. And we did speak.
All right. Anything else for the record in 24-03068, Ms. Wilson?
Not for the people.
Mr. Milks.
Not from the defense. Thank you.
You should be all set. Thank you for your appearance today.
Thanks.
That could be better. I don't know what that is. I'll be right. There's nobody on but me and you. Which I'm just, again. Yeah.
Good though. Give it a chair.
Yeah, no problem. Actually. People handle it around the applicant. We'll figure it out, no worries. Professional.
All right, Mr. Popoff, what case are you here on?
Good afternoon, Judge. I am on CAC Credit Acceptance v. Patterson.
Okay, so you're here for Mr. Burnt. I have Mr. Burnt. That's credit acceptance versus President's Patterson.
That's right.
All right. I'm just checking to see who else. Mr. Craddockville, you're here for RPM Auto Sales, is that correct?
Good afternoon. Yes, Your Honor. That's correct.
All right. Mr. Sutherland, you're here for Short South Realty.
Yes, Your Honor. Thank you.
And then Ms. Kasoga, you're here on that matter also.
That's correct.
And then Mr. Kazort, you're here on the Seal Group 3 case.
Yes, Your Honor, but I was just gonna let you know that we have an agreement worked out and we'll be submitting that.
All right. All right. So that's with you and Mr. Akanicki, is that correct?
Yeah, I don't believe he's gonna be able to make it on here, and he just wanted me to let the court know since it probably wouldn't make its way through my file quick enough.
All right. So you'll submit an order on, one of you will submit an order on my file.
Correct.
Okay. All right. Thank you, Mr. Kazort.
Yeah.
And then, ma'am, on Wikovoix, Wikovoix, that's the moniker I have you under. What is your name, ma'am?
Me.
Yeah,
My name is
right now.
Williams.
Your moniker says Wikovoix.
Oh, I don't know. I'm sorry. This is my first time using it, but my name is Prasant Williams. You guys have Patterson, I believe.
So you're Presence Patterson?
Yes.
All right. Let me rename you.
I got it.
Okay. All right, Mr. Popoff, let's call your case. That is credit acceptance. So we're on the record in docket 1901382. That is credit acceptance courts versus Presence Patterson. Will the parties please introduce themselves for the record? Mr. Popoff.
Good afternoon, Your Honor. Alexander Popoff, PA 4378, appearing on behalf of plaintiff.
And ma'am, you are Presence Patterson, is that correct?
Yes.
All right, this is the time set for a review of ledger. I have a notice in hearing that you are requesting that the court set aside the balance and lower the balance on this payment based on the ledger agreement. And Mr. Popoff, my indication is, you actually submitted a ledger as an exhibit. Is that correct?
That's correct, Judge.
Have you had the opportunity to go through that ledger with Ms. Patterson to indicate any differences you might have?
No, we haven't.
Ms. Patterson, have you had the opportunity to go through the ledger with Credit Acceptance Court in indication of an explanation of the ledger?
I was in contact with Lloyd and McDaniel.
Right, and Mr. Popoff, you are representing today.
So I'm representing Credit
law firm?
Acceptance. Yeah, so
Right.
it's actually Lloyd and McDaniel now at the law firm. Yes.
All right. So my question, Ms. Patterson, is once again, have you had the opportunity to go through the ledger with Mr. Popoff?
I have not spoken to him directly, but I have spoken to several of their representatives at Lloyd and McDaniel.
All right, so I'm going to ask you, so you have not been able to go over the ledger with Mr. Popoff, is that correct?
Not him himself, no, but I have spoken to
All right, so
several of
Mr.
them.
Popoff, would you like the opportunity to speak with Ms. Patterson concerning that ledger?
Yeah, I can do that, yeah.
All right, so Ms. Patterson, I am going to put you in a breakout room with Mr. Popoff so you can discuss the ledger. And I'm gonna put you in room 1. So Mr. Popoff, I'll put you in room 1, and Miss Patterson, I will also put you in room 1, and then we'll come back and put it on the record.
Okay.
Thank you. All right, and then is it Mr. Wilson? You can come up here, Mr. Wilson. And then Mr. Craddockville, you're here on 23-00614 for RPM Auto Sales. You can have a seat, sir.
Yes, Your Honor.
All right, I'm going to call the case of 23-00614. That's RPM Auto Sales versus Devereaux Wilson. Will the parties please introduce themselves for the record? Mr. Craddockville.
Good afternoon, Your Honor. Brent Cradaville appearing on behalf of plaintiff RPM Auto Sales P75845.
And you are Sir Devereaux Wilson, is that correct?
No, Your Honor.
You're not?
Devoye Wilson.
Okay, so I've mispronounced your name.
Yes.
All right, indicate your name for the record.
Devoye Wilson.
You are, sir, you are Devoye Wilson, is that correct?
Correct.
Okay, thank you. This is the time set for a objection to, I believe Mr. Wilson has indicated some, rather than garnishment, to pay installment payments. And this is your objection to that, Mr. Craddockville, is that correct?
That is correct, Your Honor.
All right. I have previously, we have met in this case, and I denied the motion to set aside. Mr. Wilson, you're requesting that you pay $25 a month on the $11,000 judgment. Is that correct? Okay. Mr. Craddockville, and what is the reason for that, sir?
Because I really don't have money to support my life when I get done paying my bills and all that. Like, I really don't. And me and Mr. Craddockville, we sat back there and discussed that I pay like $50 or so. But once I've been looking at my check, they've been taking more than $50 each period or however the case may be.
So I feel like. So how much have they been taking out of your check?
It's been like $80 a week.
They've been taking $80 a week from your check.
Yeah.
And so you're requesting that that it be reduced to $25 a month.
Yeah.
Okay.
Or it could be $25 every 2 weeks or so. But
that's not what you requested was $25 a month.
That's a little far fetched.
Did you want to speak with Mr. Craddockville about this?
Yes, I would like to.
Mr. Craddockville, Mr. Wilson has indicated that there may be somewhere to go concerning these payments. He was saying that the garnishment is $80 and some change. Is that what you were indicating? Does that sound right, Mr. Craddockville?
So the issue with any kind of deal I could do, his garnishment payment amount, it is weekly, but it is all over the map. I mean, the range, just to go through a few: 75, 13, 12, 6, 20, 26, 80, 68, 26. I mean, anywhere from $6 to $93 is the range I'm looking at. I can't necessarily craft a kind of middle ground resolution that I think makes sense at those values, unfortunately. Do
you want to talk to Mr. Wilson to set some type of payment plan, an installment plan that would be amenable rather than have that fluctuation? Because that seems like a fairly, I think your indication is that's a fairly large disparity between $6 and, what have you.
It is, and I'm assuming that's because we're behind something else that's maybe coming out. Maybe it's child support or something like that. But I don't know that there's anything I'm going to be able to agree to that Mr. Wilson's going to be able to agree to. The issue really, Your Honor, becomes, there's more than $100 a month of interest accruing on this account. And while, when people are making voluntary payments, I can work with them on that interest. For him to make $25 a month payment, it's just, for me to accept that, it feels frankly unfair to him. I mean, the balance is just going to keep increasing. So that's
my fear, is that you're not paying anything towards the balance, and you're just paying towards interest, and then the balance just keeps on rising.
Well, I say, like,
and it doesn't go away.
I don't mind paying, but Like I asked Mr. Like if they can produce me a car that I can drive and I can pay this amount for, like I'm just paying money for nothing. I don't even have.
But I think there's a disparity because they're behind. Is somebody else garnishing your wages?
I got child support coming out.
Yeah,
That's
so
like this, like
right. So
I'm not.
So
trying
Mr.
not to pay nothing.
So Mr. Craddock, did you want to meet with Mr. Wilson to see if there's some number that because I would think, but even $25 a week puts him at $100 a month, which is just an interest payment as opposed to a principal payment.
Yeah, Your Honor. I mean, 99 out of 100 times. I mean, I'm always willing to talk to the defendant. I just in this instance, I think it'd be one thing if we were taking $200 a week. You know, I could certainly craft a middle ground where we're taking significantly less. But because the numbers are relatively low, and I understand it's probably affecting Mr. Wilson's life, and you know, I'm not trying to minimize it, but and because of the fluctuation, I just don't know any middle ground I can necessarily come up with that would even work for him necessarily. To me, the as it's working now is probably better than any kind of installment payment would work, both for paying down the debt and being, you know, not an exorbitant amount of money. Now, if the child support payments or whatever that are coming out change and this number suddenly jumps, I would be happy to work with Mr. Wilson on something lower.
Right. I think part of the problem here, Mr. Wilson, is that there's another garnishment. And so they're behind that. And that garnishment, that makes it fluctuate. Whatever that garnishment is set at, depending, affects this garnishment. I mean, that's how I see it. And therefore, there's a disparity with how much money is taken out on this garnishment. I don't know how to fix that. I can't make this garnishment go away. And I can't tell the other garnishment that they have to change what they're doing. That's for child support you indicated. So Mr. Craddock saying that $25 a month or $50 a month, $25 a week is only going to go towards the principal. And that's kind of what we're doing right now. I would think the garnishment is just going towards the principal right now. Is that a fair statement, Mr. Craddock?
I mean, right now it's going towards interest because there's back interest because we've had this judgment for, you know, a year and a half. But I believe the amount we're getting is paying, you know, we're receiving more funds in than interest that has accrued over that same course of time. So in other words, eventually the back interest will be paid off and the payments that come in will pay, you know, probably more principal than interest once that back interest catches up. So not by a lot maybe, but it's at least progress in the right direction, I feel.
Mr. Wilson, you understand $25 a month is not going to get it. And that's on the low end. You've even indicated that, but it's about $100 a month interest. I don't find that to be an effective installment plan for this. I think this can be revisited after you visit maybe what's been garnishing for child support.
They ain't gonna change.
They're not going to change it. Okay.
Like, that's not gonna change.
All right.
This child support and all that had to wait before this even happened.
All right. Well,
so therefore, that's not going to change.
So you understand what Mr. Craddock is saying is that it's got to be $100 or more, where you're just paying it at an interest. And right now it's less than that. And we're hoping over time you can make a payment towards the principal. But the $11,000 debt doesn't go away.
I'm not even asking for that. Like, I know a debt can't go away. Like, this is what I guess people fail to realize. Like, I'm not ignorant. Like, I know the debt is not gonna go away. Other than that, I wouldn't be sitting here trying to come up with some terms of agreement to even pay towards that, regardless of the situation at hand.
I completely understand. I completely understand.
I'm a man about everything I do, which in life that I see it. But if it's affecting something in which I can't provide for my kids in a certain sense or do extra for my kids when it comes down to it, yeah, I'm going to come to some sort of thing to try and fix this.
Yeah, I think they're accepting pursuant to the garnishment, the lowest amount they can go without cutting into the principal. Without just covering the interest right now, and with a little bit in principal. Would that be a fair way to put it, Mr. Craddock-Bill? I mean, that's, I'm trying to see a number that's lower that still affects the principal, and I can't right now.
And I can't either, and I guess that's where I'm at, Your Honor. So like, I just did the real quick math on it, and it looks like about $120 a month, 119 and change of interest. And now, obviously, again, that's something where I can, if someone's making voluntary payments after a certain amount of time, I can usually work with them on that interest. It's not like a life sentence, but yeah, the payments I'm getting now, like we've got the last 4 payments. So essentially the month of November, we got approximately
And Mr. Craddock-Bill just froze.
Not much. Yeah, because I work overtime to even.
No, he was just making a record and he froze.
I don't feel like I gotta beat my body up just to.
No, I mean, we're all,
living for myself.
Mr. Wilson, we're all trying to find a way out here for you. All right. I mean, I think Mr. Craddock-Bill is trying to find a way out for you. I'm trying to find and right now there's just this might need to be revisited in 6 months, because right now there's just we can't go. Mr. Craddock-Bill can't go any lower, and I legally I'm not going to make Mr. Craddock-Bill go any lower. There you are, Mr. Craddock-Bill. We lost you for a second.
the power got cut in my building for some reason. I'm on like my
what I've indicated and I is that this can be revisited by Mr. Wilson at a later date, but right now we're kind of stuck with the wage assignment the way it is, the garnishment the way it is, until maybe you get further into it, you're able to move the debt around. But I don't see a way that I can justify lowering your garnishment payment any lower than it is right now. And that's really based on they're behind another garnishment payment that they're waiting to see how much that's taken out, which gives you 2 garnishments, which is that's part of the problem. That's part of the problem. Was that a fair statement, Mr. Craddock-Bill?
Yeah, I mean that's my position, Your Honor, and obviously I'll follow whatever the court orders, but that's my position. Yes.
What I'm going to do is I think Mr. Wilson, we can revisit this in 6 months to see where we stand. But I'm going to deny your motion for the following reasons. I can't order it at $25 a month. It would have to be someplace at like $120 a month just to get a principal payment or an interest payment. So you're not going towards a principal. And this seems like you're catching a little bit of that. So I'm going to deny the Roman, but that doesn't mean that 6 months from now you can't revisit this, just to see where we're at again, and to see if further amount has made towards the debt. But right now I can't accept the installment plan of $25 every month. I can't even $25 every week would be $100.
It'll be different if you take a portion this month, skip a month or so, then come back and get it.
Yeah, but
in the same sense, like
so
just expect me not to have nothing while everybody else keep moving forward.
Well, what I expect you to do is take care of your responsibilities.
That's what I'm trying to do.
I know you're trying to do, and we're trying to help you. That's what we are trying to help you take care of your responsibilities. Okay. So I'm going to deny the motion regarding installment payments for reasons indicated for the record.
I see it 6 months.
All right. And Mr. Craddock-Bill, I have that order regarding installment payments. I've denied it. I've checked box 3. I will sign it accordingly.
Okay. Thank you, Your Honor.
All right. Thank you, Mr. Craddock-Bill.
All right, take care. Have a good day.
You too.
Your Honor, if I may.
All right, so we're back on the record in docket 1901382. That is credit acceptance courts versus President Patterson. And Mr. Popoff, if you had the opportunity to go through the ledger with Ms. Patterson.
Judge, she did not want to discuss the ledger with me.
All right. Ms. Patterson, this is your notice of hearing to indicate that I set aside the balance or lower the balance, but you do not want to see the ledger?
I have the ledger right here in front of me. What he stated is that you wanted him to go through the charges of what is on the ledger. I already know what the charges are.
And you disagree with those charges?
Correct. That is why we are here.
What proof do you have in relation to a disagreement with the charges?
Okay.
That if you have proof, I'm going to set it for hearing. But it sounds to me, I need something in writing that you actually have proof. I don't want to show up at hearing and find out that you don't have any proof.
Oh, yes, we can. I have all the paperwork right here. That's why I paid for the motion.
And
so that
have you
guys
shared that
can
paperwork,
over it.
Mr. Popoff?
No, I did not. He told me that
Right.
you wanted him to go over the charges.
No. What I'm asking is both parties to meet and share paperwork so you can decide if this is an actual case or not. So I can see if this is actually something we should have a hearing on. If you're playing, I got a secret, and you're holding on to evidence until that date of hearing, that's not how we do things here.
That's not what just happened, sir. And I just told you what your man just said. I understand that you guys have proceedings that you guys have to do, but that's not what he just said. He got on the computer, and when it was just me and him, and he said he just wants me to go over your charges. And I said,
Right.
I already know.
I want you, and you disagree with the charge.
Correct. That's why I paid for you to
Okay,
have
and you have evidence to indicate
review it.
And you have evidence to indicate that your numbers are different than the ledger's chart.
What I'm saying is I disagree with what they're saying. Yes, I don't know what else to say and how I don't want to play word games or be specific with whatever is going on. I'm not trying to be disrespectful, but yes, I disagree with what they're charging me. That's why I paid for this.
Mr. Popoff, have you seen any of the paperwork from Ms. Patterson that indicates that the proof of her disagreement with the ledger?
No, Judge.
Ms. Patterson, have you shared any of that with Mr. Popoff concerning your disagreement with the ledger?
No, I did not. That is not what we just did.
All right, Mr. Popoff, would you like to see that before we set this for hearing?
Yeah, Judge, I would like a copy of it. I mean, I don't really know. We sent a ledger with all the payments that she made. The judgment is for $6,927. She's paid $5,604 and about $1,200 of statutory interest. This judgment is in 2019. We haven't been provided with anything to show otherwise. And we provided a ledger to the court and to Ms. Patterson as well. And
so the
What I
indication
have
is
is
Ms.
a ledger
Patterson is
from the
that she only
court.
she only owes the interest left on the payment.
there is still a little bit of principal and there's interest.
All right. So Ms. Patterson, the indication is that there's still a little bit of principal and you've had interest on your payment, and you're disputing
Yes,
that.
sir. Yes, sir, because on the 10th of October, so
I'm not
October
taking facts
15th.
right now, ma'am. I'm not taking facts.
Okay,
Okay.
well, yes, that is
So-
what I'm disputing, the amount that's owed.
Judge, she's not including interest into her calculations.
Right.
That's not what I'm saying. I'm not saying that I don't owe interest. What I'm saying to you is that on the 15th of the 21st of this judgment, the ledger that I have here, the ledger was approved on the 15th. I called you guys on the 21st of December. You guys had already added another $100 within a week. So I'm never going to be fully paid off. And then I accepted a 20% buyout, which was $900 and something. And that was before that you guys received the last $2,000, which was received coming in from my
So Ms.
taxes.
Patterson, what are you
Why I
indicating that
owe
you owe right
$2,000.
now?
I'm trying to figure that out. You guys, they're not going to get what they're thinking.
So if we had a
that's why
hearing on this, you couldn't even tell me how much you owe?
what I'm trying to tell you is what they're trying to do is rob me. And I'm not going to go for that. That's what I'm trying to tell you. I got the original balance was $6,200. That was what the original balance is.
That's
all I can tell
incorrect,
you what I
Judge.
originally
Judge,
owed.
that's incorrect. It's almost
The
$7,000.
balance,
judgment.
no, it was not. You guys record all my calls.
Ms. Patterson, you're not
And it's right here.
let's okay. So what we're gonna do is everybody's gonna show up in person. You're gonna meet, you're gonna trade paperwork, and we're gonna have a hearing on it. And then I'm gonna decide. All right, Ms. Patterson?
That is fine with me.
Mr. Popoff, I think that's what's required here, since there's a dispute as to payment. And so I'll have you come in with the ledger and explain the ledger to Ms. Patterson. If there's just still a dispute, we can put it on the record.
Judge, I have no problem with that. The only thing is I did try to explain our ledger to her in the breakout room. And the judgment.
I don't agree with it.
Excuse me, Ms. Patterson.
Ms. Patterson, let Mr. Popoff talk.
And the judgment amount that she's stating is incorrect, Judge. She keeps saying $6,200. If you look at the judgment, it was for $6,927, Judge.
Right.
And she's not even giving us.
I have the judgment for $6,927. That's the judgment that was ordered.
That's right.
Okay. And they want more than what I'm saying to you is I paid more than half of what they have already asked for. So
that would account for the interest that you pay.
Correct. And that is correct. When I called them on the 21st, they offered me a 20% buyout, which was $900. And then they received the $2,000 check. So really I am owed $1,000 back because I met the arrangement that they
Ms.
did.
Patterson, this sounds like math you're doing on your own.
No, what I'm telling you is if they give me a 20% buyout, which was $900, I asked this young lady when I was on the phone, Judge, if I need to get a lawyer so that because what you're doing to me is basically you're combating me and you should be working with me. You're basically
all right. So what I'm going to do, Ms. Patterson, Ms. Patterson, you got to stop talking, okay? What I'm going to do is I'm going to adjourn this for 30 days, let you go get a lawyer, and then that lawyer can contact Mr. Popov, all right?
No, I will be back in your courtroom. Now you have
you just told me you're going to go get a lawyer.
I'm going to go get a lawyer, and
Ms.
they're going to go to court. I can still come to court. You don't.
You gotta stop talking.
I will come back to court.
No, you just indicated that you're going to go get a lawyer,
and we will come back to court.
All right. So I'm going to adjourn for 30 days. So December 5th is today's date.
Like that.
Ms. Patterson, you should stop talking right now. Okay?
Mm-hmm.
You should stop talking right now.
Okay.
For your own interest. That's what I'm telling you.
Okay.
And we are going to reconvene in January sometime.
January 13th at
Mhm.
8:30.
January 13th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. And Ms. Patterson, I think you'll be represented. I'll get an appearance and we'll file an appearance with Mr. Pop-Up in the court. And then we'll go from there to explain some of these issues to you or to have an actual hearing. All right?
Thank you.
All right. Mr. Pop-Up, you have that date of January 13th at 8:30?
I do, Judge.
All right. Please bring in anything you need for the court to mark, anything that's tangible, because we might have a hearing on that date. Thank you, everybody, for your appearance today.
Thank you, Judge.
No, doing criminal. What is wrong with him?
I'm just writing some notes. We'll wait for now.
Judge, I'm sorry, I forgot to ask on the record. Will we be getting a notice?
Sure.
Will we be getting a notice as well for the
You
hearing?
will be getting a notice for that date. So that'll be, and it'll be sent out to Ms. Patterson and yourself for that January date.
So Judge, it's
Okay.
gonna get sent to Carol Burnt.
Okay, it'll probably go out to that Burnt Law Firm, Carol Burnt Law Firm.
That's fine, as long as it's the Warren address. Truthfully, I don't know if I will be there, but somebody from our firm will be there for sure, and it'll be the same.
All right, let me make sure. Is that the Warren address?
Yeah.
Oh, it is. It is. All right, you should be all set, Mr. Pop-Up.
Thank you, Judge.
Thank you.
Your Honor, if I may.
Mr. Sutherland, you're here on 24055535.
It is, Your Honor. If it'll please the court, this is just a simple stipulation and agreement to dismiss the case. It's just been a hard act to follow the last couple cases.
Boy, did you say a mouthful there. All right, so I'll just call that, and then you can place it on the record. So we're on the record in docket 24055535. That's Short South Realty versus Kalimba Kasoga. Appearances for the record, Mr. Sutherland.
Yes, Your Honor. Again, thank you. Good afternoon. Attorney Kevin Sutherland, P81681, on behalf of plaintiff.
All right, and then I don't see I do see Miss Kasoga. You'll have to Kalimba Kasoga. You'll have to unmute.
Hi,
All right, and ma'am, you are Kalimba Kasoga. Is that correct?
yes,
Perfect. All right, this is the time set for the motion, and Mr. Sutherland has indicated before, it sounds like the parties have reached an agreement and a dismissal is oncoming, but I'll let you make a record, Mr. Sutherland.
Yes, Your Honor. Thank you. I did have an opportunity to speak to Ms. Kasoga today. I think we had a meaningful and productive conversation about how to move forward in this matter. Before, Your Honor, working its way through my file, and the reason for the appearance today is a stipulated order for dismissal. Both myself and Ms. Kasoga have signed it, and we both have copies of the same. In that order to dismiss, it will be dismissed without prejudice. The only condition is that the defendant, Ms. Kasoga, was going to make a payment today of $307.63. That's today, December 5th, 2024. There is currently escrow funds in the amount of $1,000 held by the court. That will be dispersed to plaintiff, made payable to plaintiff, and mailed to plaintiff at the address above on the dismissal form. It is the amount of an unpaid judgment through November 2024 of $1,307.63. What's not in that order to dismiss, I would just add, is that we put a credit on the account of $198.90. And again, this satisfies the balance through November 30th. Any proposed order seeking an order of eviction would not be needed or executed under these circumstances. And hopefully the parties will continue communicating going forward.
And Ms. Kasoga, is that a fair and accurate statement concerning the agreement with Mr. Sutherland?
yes,
All right. And then, Mr. Sutherland, that dismissal will be that condition. It sounds like a conditional dismissal, but that'll be signed, that'll be advanced to you. Do you need Ms. Kasoga's authority to sign on her behalf, or has she been able to review all that?
Your Honor, this one is a little bit different. It's actually a straight dismissal. This case came before the court upon a reinstatement and entry of a judgment after a conditional dismissal. So in this case, a stay was entered by Ms. Kasoga's motion as it relates to the order of eviction. So this is simply a stipulation to dismiss, but under order to dismiss, the further conditions provide for the close of the escrow account with the court and the disbursement essentially of the $1,000 that's being held by the court. So it's simply just to facilitate that payment to plaintiff and account towards her balance.
All right, and the order will have all that in it?
It is, Your Honor. I do have it in front of me, and it was submitted a little bit ago, and I know it's working its way through my file. As soon as that's signed, we'd like to get a copy to Ms. Kasoga as well.
And Ms. Kasoga, the only reason I'm asking these questions is because another judge signed the to place the order for that you were in escrow, and so I'm just making sure I understand the terms of the agreement that you've entered into concerning the dismissal in the matter. So that's fair and accurate, Ms. Kasoga?
Yes, I mean, I'm obviously not a lawyer. I don't understand everything, but I did have a lengthy conversation with Mr. Sutherland, and there is $1,000 in escrow. I've already made a payment of $310. So he said that would satisfy what caused the conditional dismissal to not be met and what did trigger the eviction, that I did come into court and stay that eviction. So now currently there should just be no eviction process. It is just dismissed at this time.
All right, so Ms. Kasoga, you I think you understand everything. I think that was an accurate assessment of all the things. So the escrow will be returned to the plaintiff. Will go to the plaintiff, and then the dismissal will indicate the credit for the amount you paid.
Thank you.
Thank you.
All right. Anything else for the record? I'll await the order to follow. And my understanding that's already in my file. Anything else for the record in 24-05535, Mr. Sutherland?
No, Your Honor. Thank you. That was submitted about 12 o'clock. It should be there on its way, 12:30. Thank you.
All right. Thank you. Ms. Kasoga, do you have any questions of me?
I do not. Thank you.
You should be all set. Thank you for your appearance today.
Thank you.
Thank you.
And then Mr. Goethals, what case 0309? You're here for Discovery Bank or Taylor Dixon?
For the plaintiff, Discover Bank, Your Honor, and this matter has been resolved.
Okay. Well, I'm not going to argue with that. Let's pull that case up. And do you know if Miss Dixon is going to be here, or Taylor Dixon is going to be here?
I do not, Your Honor. Given the resolution of the case, she may not be appearing.
All right. Well, we can waive her appearance, but we'll place any resolution on the record or that you have. All right, sir?
Certainly, Your Honor.
All right. So we're on the record in docket 24-03097. That's Discover Bank versus Taylor Dixon. Appearances for the record, Mr. Goethals.
Yes, good afternoon, Your Honor. Michael Goethals. It's Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Goethals, you indicated that there was a resolution in this matter. What is that?
It involves the filing of a consent judgment, which I understand was in fact e-filed on December 3rd.
Okay. So it's a consent judgment and it was e-filed on December 3rd. Do you want to place any terms on the record concerning that consent judgment, Mr. Goethals?
No, Your Honor. Actually, I don't have the specific payment terms in front of me anyway, but they would have been sent to the defendant, so the defendant would have that in writing.
All right, and the defendant would have that in writing. Do you know if Taylor Dixon signed that document, or is that would be my That would be my understanding.
Yes, Your Honor, I do have actually a copy of the signed judgment. It looks like it was signed by both the defendant and attorney Trevor Cruz.
All right. All right. So I will await the consent judgment concerning this matter. As signed by both parties. And then we place it on the record, but Ms. Dixon's appearance is being waived because she may have thought that signing the document was the finality to this proceeding. Is that a fair statement, Mr. Goethals?
Yes, Your Honor. I think that is a definite possibility.
All right. All right. So I will await to sign the consent judgment, and then each litigant will get a copy sent to their last known updated address. Anything else for the record in 2403097, Mr. Goethals from Discover Bank?
No, Your Honor. It sounds like you do show that filed judgment being in the system at your end.
I don't know. If I had more prowess concerning the on-base system, I could look it up. I think it is in my queue to sign, though.
Very good, Your Honor. In that case, there's nothing further from me.
All right. Thank you for your appearance today. You're all set.
Thank you, Your Honor.
All right. Mr. Mastrossi, you can unmute.
All right.
And Mr. Mastrossi, I have you here as a plaintiff on a discovery issue with Shailene Nelson. Is that correct?
Yeah, that is correct, Your Honor. I was
I was looking at my notes in this file on base, and it said that on that file we corrected an order on the record, signed and scanned, and order was completed. Does that sound correct?
Yes, you signed a judgment, correct.
All right. So what is the follow-up discovery? I'm trying to figure out why we're here.
The discovery was to get her information, which would be like her social and yep. And
is that an order? Is that an order to collect on the debt?
Yeah, it's just to get information so that I can fill out the debt collection forms.
Yeah, and Miss Nelson, I don't know. So did we put on the record that we were going to meet on this date, or did she receive notice of this?
So I tried to get an officer of the court to locate her. They were unsuccessful in locating her. So
all right. So my take on this, and I'm not giving legal advice, but I don't know if she has notice of this, and you may have to seek an alternative way to provide notice for hearing before I can default her for not giving you the information that you're required for the debt. Does that make sense?
Yeah. I was just told that I needed to just refile another subpoena to try to get that information.
I think what you're doing is collecting on the order that's been signed, and you're going to have to go through a collection process. And part of that is giving her notice and if you don't know where she is, it might be required that you get notice through a posting or something else.
Okay.
All right. And that's my general knowledge of the situation, but I can't default her for non-appearance if she doesn't have notice of this.
Understood, Your Honor.
So it sounds like you might be depending on the amount of debt, some type of talk to somebody or or you can go to michiganlegalhelp.com. They have some instructions on collecting on an order.
All right. Thank you, sir.
All right. Thank you. All right, so we're on the record in 24-4531. That is JP Morgan Chase versus Mike Lee. Will the parties please introduce themselves for the record from JP Morgan Chase?
Good afternoon, Your Honor. Keith Sparks here on behalf of JP Morgan Chase.
All right. Sparks. And then Ms. Keener.
Melissa Keener on behalf of defendant Mike Lee, and Mike Lee is also here with me.
All right. And sir, you are Mike Lee, is that correct?
Yes, I am, Your Honor.
All right. I have two files considering both these parties. I have 24-4531 and 24-4535. Is there any reason why these files can't be called together, Mr. Sparks?
No, I don't have any objection to that.
Ms. Keener?
That would be my preference.
All right. So we're gonna also call 24-04535 with the same appearances from Mr. Sparks and Ms. Keener. This is set for pre-trial in the matter. Mr. Sparks, if you have this is generally how we do pre-trials. I'm probably telling you something you already know. You can meet together to discuss. We have lawyers involved, so you can submit a joint pre-trial statement, as you know. And then if there's a difference, we can place that on the record or set it for a hearing date. Usually for the pre-trial, what we're doing is we're just setting a time for discovery. And then if we hold a motion for summary disposition in abeyance somehow, pending discovery, because most of our exhibit lists and everything comes out of discovery, as you know. We can do that. I give the parties a chance to talk, Ms. Keener and Mr. Sparks. I can place you both in a breakout room and you can talk about some of the issues that led to the filing of both these complaints. Or we can go ahead and fill out a pretrial discovery sheet that I have. The civil department hates that because that means they have to read my writing. So they're not really happy with that at all. But that's always an option. So Mr. Sparks and Ms. Keener, it's really up to you. How do you want to handle this pretrial?
I'm willing to go with however Ms. Keener wants to go. I know that I haven't spoken with opposing counsel, but you have been in contact with Joe from my office. There was actually 4 cases from JP Morgan Chase versus Mr. Lee. 2 of the 4 have been closed for fraud, and we're just trying to do some more investigation into these other 2 files. And so what I would request, typically 60 days, but if we could do 90 in this instance, I guess that's all I'm really looking for. The parties kind of know where we are, but Ms. Keener, I'll let you fill anything in that I missed.
Ms. Keener, is that a fair statement concerning setting this out a little bit?
I'm absolutely fine with setting this out a little bit. I was unaware that there have been 2 cases that are going to be dismissed, but I'm all for them conducting their investigation and us not accruing unnecessary cost and attorney fees. So
let's do this. Let's set this out, and we'll just set this out for another pretrial since this does seem to be in its own investigative mode. And I don't think we have to call it a discovery hearing. We'll just set it out for 90 days for another pretrial. That doesn't do anything to the case. It just, but we can place in abeyance, and therefore JP Morgan can do an investigation and see if it lines up with the other cases, and then we can go from there. How does that sound, Mr. Sparks?
That sounds great.
Ms. Keener?
that works for me, Your Honor.
All right, so we'll set a control date.
March 3rd.
And we'll adjourn, you're good, adjourn this pretrial. And I have the date of March 3rd at 2:30.
Your Honor.
So we'll set both.
I'm sorry.
Go ahead, Ms. Keener.
I'm scheduled to be out of the state on March 3rd. I'll be returning on March 4th. I don't know if there's a different date we can
Maybe
get.
the next week?
Yeah, that would be great.
Let's try the March 10th.
March 13th.
March 13th. How's March 13th?
That works for me, Your Honor.
All right, so let's set both of these, adjourn this pretrial for additional investigation. And then if it doesn't work out, we can always have a pretrial and go forward. But since there's other files here, we'll adjourn this pretrial and on 24-04-531 and on 24-04-535 for March 13th at 2:30.
Thank you, Your Honor.
Does that work for you, Mr. Sparks?
Yes, that does work for me. And sorry, we have about 4 cases, and so I was a little mixed up. But yeah, so 4531, at least on my end, Ms. Keener, says that it's pending dismissal. 4532 and 4535 are the 2 that are still open and ongoing. So you'll probably receive a dismissal for, it says pending dismissal on 4531 and 4533.
Okay.
All right, so one of these is 4531 is one we have.
Right.
4535 would be the adjournment then.
That sounds great.
All right. All right. All right. Anything else for the record on either 24-04-531 or 24-04-535, Ms. Keener?
No, Your Honor.
Anything else, Mr. Sparks?
No, Your Honor.
You should be all set. Thank you for your appearance today.
Thank you
very much.